Hi everyone, thanks so much for coming today. I assume because you will have all seen the title of my talk that most of the members of the audience are going to be students who might be interested in entering the competition this year. So I hope it's going to be useful for you. I am going to walk you through how I wrote my essay, and so I will be talking about the research that I did and some of the conclusions that I came to. So hopefully it will be substantively interesting, as well as thinking about how to go about writing an essay. And then afterwards, I don't think I'll end up speaking for the whole length. We can have a bit of a discussion if anybody wants to about the topic of the essay, but also about how you go about writing an essay for a competition like this, if anybody has any questions. So also feel free to chip in if anybody has a question as I go. Just stick your hand up or shout. I don't mind at all. So I first got interested in animal law in 2016 when I went away on my year abroad, and I had a bit of space to think about what I wanted to do with my life, and I was a languages student at that time, so I hadn't thought about law very much. And it was then that I realised that animal law was a thing and that A-law was a thing, and it was pretty soon after that that the title for the 2017 essay competition, which I think was about puppy farms, was released, and I thought long and hard about whether to enter or not, because since I wasn't a law student, I wondered about whether I would have the right skills and the right knowledge to do it. I decided not to in the end, and the same thing happened the year after, when the title was about including decapods within the protection of the Animal Welfare Act, which is the crustacean compassion campaign, which you may well have heard about. Now, as it happens, when I finally became a law student and I entered the 2019 competition, which was about legal personhood for animals in the UK, we can talk more about the detail of the title later on, I realised that being a law student didn't help me at all answering the question, and that's because as a lawyer, and especially as a law student, I think, you are always researching a new area whenever you do a piece of work. Just as when you're a practicing lawyer, it's very rare that you start a piece of work and it's on something you're already familiar with and you already know the answers. You don't need to go and look it up in the books. So for that reason, on the off chance that there are any non-law students in the audience today, I would advise you not to take the path that I did and to enter the competition, even if you don't feel like you have the experience in law that a law student would do, because I don't think that they have a particular advantage. So something that I thought was interesting about the title in my year was how it seemed to be a legal question to the exclusion of ethical questions. The two titles before I entered at the start of this year both had a mix of law and ethics, and that was why I thought I might have been able to enter. But when I looked at the title and when I wrote my essay this year, which was let me get the exact title, Explain the Potential Significance of Granting Legal Personhood to Animals in the UK, it quite soon became clear that it was going to be something about how the political reality and the legal mechanics of a certain development would work, and whether it was a worthy goal for animal lawyers to pursue, as opposed to why should legal personhood be the goal for animal lawyers, or what framework of legal philosophy best explains why legal personhood is an admirable goal. It was much more rooted in the political realities, and that I thought was interesting, because while animal law is a very multidisciplinary topic, as we can tell over this conference, you have lawyers and you have philosophers and you have scientists and veterinary scientists all talking to each other about their different disciplines, and there's quite a lot of cross-fertilization going on in the talks, which is great. You do sometimes get a topic like this essay topic where you have something in isolation, and so on the one hand you need to keep an eye out for that to make sure that you are answering the question that's actually set, and you don't answer a question about the nature of legal personhood, where legal personhood comes from, when you're actually being asked a question about whether legal personhood would be a good thing practically for animals in the UK, what would happen step by step. And I think part of the reason maybe that my essay did well. It's hard, by the way, a little caveat, because I haven't spoken to any of the judges, because I haven't seen any feedback, I may be completely wrong as to why my essay did well. So do take everything with a pinch of salt. Hopefully you'll be able to read it in the next edition of the UK Journal of Animal Law. I think it's going to be there, and so you can make your own judgment of it there. But something which I tried to do, and which hopefully was the right thing to do, was to write the essay that I was being asked to write rather than the essay that I at first wanted to write. And this was helped by the fact that it's a very strict word limit. So at least this year and previous years, it's been 1,500 words, which when you start to dig into a topic like this, and if it's something you're passionate about, is not a lot of words. And so I found I had to go through quite a long and painful process of cutting down words to make my argument really slim and make sure there was nothing that wasn't essential to my argument in my essay. And that, I think, ties in with trying to answer the question that's actually set and not just putting all of your thoughts on the topic onto the page. So just quickly to go into what I read about when I saw the title, I looked at two areas mainly. One of them was about theories of how personhood works more broadly, not just animal personhood, although that was included, of course. And the second area I looked at was alternative models of animal status under the law than the object status that animals currently have in most legal systems. Now, if you look at personhood in legal academic writing, and especially in legal cases, the most obvious trend that comes up is that it's about corporations, because companies are the major example of non-human entities that have been given personhood by courts or by legislation. And if you want to see what legal personhood is, or what it could be, or what different people think it is, then corporations are the places to look. And so I read through some of the literature on that, and the most well-regarded, most often referred to article you'll find quite quickly is John Dewey's 1925 article, where he basically argues that personhood can mean whatever you want it to mean. It can mean whatever a judge wants it to mean. It can mean whatever a lawmaker wants it to mean. There isn't a fixed content of a set of substantive rights that come with personhood. And as I was reading into the animal rights legal theorists who've followed on from that, they had broadly the same impression. There is some debate over whether it's possible to have personhood without having any substantive rights at all, or whether it's possible to be if you can only have personhood if you're at the same time being granted a substantive right, for instance, the right not to have suffering inflicted upon you, or the right to bodily freedom, or whether it's possible to be a person and yet not have any of those rights that you can then rely on in a court to stop somebody from doing something to you. But in general, the academic consensus appears to be, and I think Stephen Wise has become one of the more prominent people who believe this since the Non-Human Rights Project has become so prominent, is that legal personhood is, as it were, an empty status. And so you will need legal personhood if you want to have any substantive rights. But if a court grants you any substantive rights, then they have to at the same time recognize you as a legal person. But having legal personhood itself doesn't give you substantive rights, not if the court doesn't think you deserve them. So after having read that, and having thought about the political and legal context of the UK, and the most important elements of that for this essay were the fact that we have an unusually strong system of parliamentary sovereignty in the UK, where we don't have a Bill of Rights or any set of rights that all persons enjoy, which can't be overruled by a simple act of Parliament. It quite easily followed from that legal personhood is not a miracle cure for animals in the UK, partly because it's unclear exactly what could prompt a judge to decide that a certain animal would have legal personhood, partly because they wouldn't be obliged to give any particular set of rights to the animal if they were to grant them legal personhood, but mainly because if that were to happen, Parliament would be completely free to pass legislation that would strip the animal of those rights, because Parliament can do anything. Well, in the last few weeks you can't really say anything with certainty about parliamentary sovereignty, but as far as we know and as far as we're taught, Parliament is able to override any common law rights that any person can be said to have. And for this reason, I argued in my essay that there is not much point trying to argue for animal legal personhood in the UK if the political mood of the country has not yet advanced far enough that Parliament would not simply override that. Because, for instance, if a court decided that all animals above a certain level of cognitive complexity, which would probably include some farmed animals in reality, because otherwise it's very difficult to explain why you're drawing the line. If the court decided that those animals were legal persons and had a few substantive rights, the economic impact and the social impact that would have on our society, which so much depends on the exploitation of animals, which can't deal at all in its present state with animals with any fundamental rights at all, Parliament would just overrule that straight away and pass an act saying, just to be clear, doesn't matter what the courts say, animals don't have any fundamental rights. And that kind of backlash could be even more damaging than remaining in the system as we have it now, because it might mean that even when the public mood moves further in favour of animals, and when we become more technologically and emotionally able to live our lives without having to exploit animals at all, then there won't be a piece of legislation sitting in Parliament acting as a roadblock or something that we have to explicitly repeal. So that basically meant that my essay was a little bit of a dampener. It wasn't very thrilling to read, because it was basically saying that this isn't a particularly exciting goal in the UK. It may be exciting in places such as the US, where they have a codified constitution which includes a Bill of Rights, and where if you manage to get a certain kind of animal, a certain species or a certain individual to be included as a person, then they're captured within the Bill of Rights definition, and then they're safe from whatever politics might want to do to them. Basically, in my essay, I argued that politics is too powerful a force in the UK because of how parliamentary sovereignty works, for us to be able to disregard it when we're working out what the priorities for animal lawyers should be. And so by all means, and I think it is a brilliant idea, because I think it's really fascinating and ethically right, as well as potentially useful, animal lawyers and animal law academics in the UK should continue to study and write about and argue for animal personhood, but it is only going to succeed really if it works alongside the education campaigns and the political representation campaigns, as well as advances in food technology and everything that is making it easier for humans in this country to live their lives without relying on the exploitation of animals. If it's part of the broader campaign, then it can serve a purpose. But it's not going to be a magic bullet that rescues all of the millions of animals that are exploited in the UK, unless we can take the public mood with us at the same time and at the same rate, which sadly is going to be a slower process. So, in terms of advice quickly for anybody who wants to enter the essay competition, first of all, I would keep your eyes open for the title to see it as soon as possible. I think it's released in November each year. October. So make sure you see it as soon as possible, because if it's working away in your subconscious, then you can start to come up with what you think about each side before you really get stuck into the research. And once you've had a bit of time to mull it over, start to look up what the main academic thinkers and legal cases, if relevant to the title, have had to say about the topic. Because I think one of the things that the judges like to see from students is the ability to really research thoroughly into an area and then critically use academic writing as well as case law. It just so happened that the title this year didn't involve a lot of case law, because there hasn't really been case law about this in the UK context. I wrote briefly about Somerset and Stewart, but it was slightly a passing mention. So you need to try and get as much detail into your head as possible in my opinion, before you start working out what your arguments are going to be. And make a note of everything as you go on, either in a document or in a notebook, so that your referencing isn't a nightmare afterwards. Write down where you found everything and pull out any quotes that you might want to pin into your essay. And if you immerse yourself in that for a few weeks, then you can start to have a map in your head of who the main thinkers and opinion havers are, who matches up with whom, who agrees with who is in opposition to whom, and that helps you to start to position yourself. Once you then work out, right, I'm now informed, I know what the arguments are, what do I think, you can position yourself in agreement with people and in opposition to some people. And that means that you're then using their arguments critically as opposed to parroting them. And it's more impressive if you can take on their strongest arguments and say, well, this is interesting, but, rather than just saying, this is what this person said, whereas this is what this person said. You need to make it your own essay. Once you've done that, what I do, I tend to write in quite a structured way, is I will have a think about once I've mulled it over enough so that I know roughly what I want to say, I will spell it out in as few logical steps as I need, so maybe 3 or 4 sentences. I think X, if X, therefore Y, I also think Z, and if Y and Z, then therefore this is my conclusion. And so you have a first plan, which is just a few sentences, 1 line, 2 line, 3 line, 4 line. And once you've done that, you can pin the little nuggets of case law and academic criticism that you have in your notes to each line to beef it out, as it were. And then you can flesh it out enough so that it flows. I think that is a better way to write an essay like this with a very strict word limit than to simply sit down and let it rip, because I think if you care about this topic, and I think anybody here writing an essay about animal law is going to care about this topic, you will probably write a lot more than you're allowed to, and you will hit the midpoint of your argument when you reach 1,500 words, and you'll have no idea what to do. If you write 3,000 or 4,000 words by the end, you'll have to really pare it down or take out whole steps of your argument, which then makes it very difficult to flow. So even if you will inevitably have to cut down a bit when you finish, I think building the skeleton first and then putting the flesh on the bones after you have got your skeleton works better than starting from the top and writing it in full all the way to the bottom. And if you have been taking notes of your reading as you go along, then it won't take you very long to put in the references. But you do need to take a lot of time to make sure your references are completely consistent, make sure you know what system you're supposed to use, because that's another mark of professionalism when it comes to submitting to judges like this. The essay is going to be going into a professional academic journal, and so you need to make it look like that and have no mistakes in your references and make it look completely consistent. So I think that's my advice. I'm not sure if I have anything else to say about the process of writing the essay. The only thing I would say is that if anybody was at Josh's talk this morning, I think that was a really good example of how legal and ethical debates about a certain issue, which for him was personhood, can really talk to each other really well. So my essay, when you read it, was strictly legal and political, but the title really dictated that there wasn't any room for ethical debate. But he made a really compelling ethical case for legal personhood and showed how it integrated, and that's something that I've been slightly thinking about, is if you believe strongly in certain ethical statuses for animals, and you may even call it personhood as an ethical status for animals when they have certain rights in your view, I struggle to see how you get from there to integrating that into a legal system, which is so obviously created by humans. It has no, in my view, intrinsic moral status. You can tell that I'm not a natural law theorist like Josh is. And they're just speaking completely different languages, this ethical system and this legal system. And fortunately, I didn't have to deal with my problems about that in this essay, but it would be fascinating to hear if anybody here who knows more about moral philosophy than I do, or knows more about the interplay between moral philosophy and the law than I do, knows how to reconcile that, because I think the most compelling political arguments that we can make as animal advocates, and we will have to make if we want to make animal personhood a reality and improve, well, make animal rights a thing in this country at all in a legal sense, is we will have to make a compelling emotional argument for the respect of animals which amounts to legal personhood. And to do that, we need to work out what legal personhood means in an ethical sense, and not just this is the system that humans have created and this is a slot that we can conveniently put animals in because it would prevent suffering. And that's a good reason to do it, but I don't know whether that's going to win the argument in the public square. I will grind to a halt there. If anybody has any questions about writing an essay like this, please do ask me. I'm far from an expert, but it'd be nice to have a debate about it and swap notes and advice. The last thing I just want to say is, as Natalie kindly pointed out, I am running a mooting competition this year, which is called the Cecilia Moot, which is named after Cecilia the chimpanzee, who was named a legal person a few years ago, not in the UK sadly, and this is the first year that this moot is open to any students at any university, so I'd really like as many of you as possible who would like to get involved. If anybody's an A-Law ambassador, it would be great to hear from you to see if you want to take a role in organising the competition. Otherwise, please do talk to me if you're interested at all, and we can work out how you can take part or be involved in running it, because it should be really exciting this year. Well, thank you very much, everybody. That's it from me. Thanks.